everybody. Welcome. Happy Friday.
Up there, Rob Thomas.
Hey, Julie. Julie, I don't know if you're recording it, but we're recording it too. So if you need us to send it to you, we will. Let's see. Good to see everybody. I think I saw Rob. Yeah, there's Rob. Thanks for coming. Like I said before, happy Friday. We got a lot of people loading in, so just give us one more moment. Hey, Chip. Let's see. All right, let's see. So happy Friday. Like I said before, welcome to December. We are rushing right into the holidays. Time has really kind of been moving really fast post-COVID, right? It feels like we lost 3 years somewhere, and the holidays are just rushing right at us. So Merry Christmas, Happy Hanukkah. I think they overlap this year, so I think they're kind of Happy Christmas, Happy Hanukkah, Merry Christmas, Happy Hanukkah. And so I hope everyone has a great holiday. Hope you stay healthy. There are a lot of people getting COVID again, believe it or not. I hope not in your families or your communities, but hearing a lot of that these days, going to meetings and in person and seeing residents who say, hey, I just got over a bout of COVID. But it does seem that the boosters are helping with getting over that pretty rapidly, which is a good thing. Hopefully it stays that way. So we do have a dog of the day today. We had 2 dog of the day submitted. We went with Lulu. This is Lulu. I hope you can see Lulu okay. Lulu belongs to Alba Tamboro, who's a board member over at Forestgate Community. And she says that Lulu loves Christmas gifts. So Lulu looks really comfortable right there. I know my dog would love that. I think it's a dog bed that Lulu's lying on. I think, yeah, Jet would love that. But thanks for the costume too. Costumes are always fun. There was, like I said, another dog submitted, which we will do next month, which is Terry Vigiano's dog. So thanks, Terry. We haven't forgotten about you. We haven't missed you. But that's the dog of the day. So the usual announcements, the business stuff is, this is not legal advice. It's for informational purposes only. There's no attorney-client privilege. Nothing will be kept confidential. And if you need attorney advice, legal advice, you have to go out and hire an attorney and enter into an attorney fee agreement. But again, thank you for coming. So we'll jump right in. Today's topic is enforcement, right? A nice, cheery Christmas, Hanukkah, holiday, love everybody topic. But as you know, lots of people move into planned communities. And then when the association tries to enforce the restrictions, they're like, why are you busting my chops? You're like, you moved into a planned community. We want it to be nice, right? So abide by the rules and regulations. So we talk about the documents themselves, which are, usually the declaration. Usually the declaration relates to homeowners associations. Master deeds generally relate to condo associations. And then we have the bylaws, the rules and regulations, etc. So generally speaking, the declaration and master deed relates to property rights and restrictions. Bylaws relate to corporate governance, corporate powers, and corporate duties, generally how it works. And the rules and regulations essentially flesh out the restrictions that are contained in the master deed or declaration. So the association, under its master deed or declaration, may have leeway to specify what's permitted and what's not based on a board vote or board resolution, passing rules and regulation. And once they're in place, the board can enforce them. So the next topic is rules should be enforced or eliminated. A lot of people, a lot of associations have rules and regulations on the books that they don't enforce. That undermines your ability to govern, right? That undermines your ability to govern, and it makes people unsure as to how to manage their lives, right? So you say, I want to extend my deck 2 feet, and there's a restriction that says, no, you can't restrict it by 2 feet. And the next door neighbor says, the board never enforces that stuff. Don't worry about it. And in fact, the board doesn't enforce that stuff. You should take that restriction off the book then. And we have a number of questions coming in, which is really good. Some questions already. And we will address the questions. But again, please, if you have rules and regulations that are not being enforced, that you're not enforcing, just modify them and take them off the books. If you feel that you need more rules and regulations, just pass them through the association's board. The anti-waiver restriction, which is
Frank, can I make a
jump
just
in.
a quick comment? Yeah, hi everybody, Mike Palulak here. Just a quick comment on that. So if you are not enforcing your rules and then you seek to enforce them, judges sometimes will not allow you to do that. So we had a case in Ocean County where there was a retaining wall put up around in the front of a single family home unit. And the board said, you can't do that. That violates our rules. And in fact, they had not been enforcing it. And throughout the course of the litigation, we found out that there were several more in the community that had them for years. And the judge was not willing to enforce this restriction against this one owner while others were permitted to do it. So just keep that in mind.
Right. Thanks, Mike. So that goes to both sides of the issue. The one is if you have the rule in the books, enforce it or change it if you don't want to enforce it. The other thing is most governing documents contain what's called an anti-waiver provision. Thanks, Eileen. An anti-waiver provision basically says that notwithstanding the fact that the association does not enforce a rule or regulation stated in the governing documents or rules and regulations, it doesn't mean the association waives them, right? Now, what Mike was talking about is a special case, which involves two things. One, if an association stands by when a person is investing significant amount of money, like building a retaining wall, and does nothing, and then after the fact seeks to have it ripped out, courts will say that's not equitable, right? The association knew about it. The association saw that this person was spending a bunch of money and going to great lengths to do something. The association may be stopped from enforcing it at that point. That's one, the estoppel argument. The other thing is too, disparate enforcement. We have that further down on the chart here. You can't just selectively enforce your rules and regulations. You know, it's fine for these people to have a retaining wall, but the other people we don't like so much, so they can't have a retaining wall. So selective enforcement comes to mind with some of the issues that Mike was describing as well. You don't want to get into selective enforcement. Life, health, safety threats we've talked about before. So my opinion on life, health, safety threats is they have to be stopped, right? So you need an immediate violation letter. You need to call the police if it's a true life, health, safety threat, whether it's association member or on association member, or association member on an association employee, representative, vendor, etc. And as you've known from the past months, we've had lots of those cases. We're involved probably in about 10 cases like that right now, life, health, safety, where people are roaming around the community, either threatening their neighbors or threatening association board members, managers, or vendors. The life, health, safety has to be eliminated, and the police do have to be involved, not only to try to stop it, but also to build the record so that if we wind up either in municipal court or state court, we can show the judge that it is a problem and we had to take steps to do it, to take care of it. Law enforcement and municipal courts. As I said before, state courts are not very well equipped to deal with these kinds of situations in terms of rule violations in association world. Oftentimes, the individual winds up in municipal court with a harassment complaint. So we've had a number of board members who were, for example, harassed out on the common property, and they want the association to go to state court to stop the gentleman or woman from harassing them. And ultimately, often what happens is the state court judge wants the complainant to go to municipal court and have the person stopped that way. State court judges have not been very open to addressing these types of issues, just so keep that in mind. Nevertheless, we have to talk about whether or not the association should attempt to go to court, state court, and or municipal court to stop the conduct. We always say yes. We always say the answer to that is yes, because the last thing that you want to have is a threatening situation that you find out about. You don't really do anything or don't do enough, something really, really bad happens, and the person either sues you or is severely injured, hurt, or killed. And the question to the association is, what did you do? Why didn't you go to court? Why didn't you deal with the issue through the courts? And you say, well, we didn't think we'd be successful and we didn't want to spend the money. That's not a great answer, right? When you have a really bad case. in today's world, you watch, I'm sure all of you watch the news every day and look at things on the internet. People just are not respecting boundaries. Since COVID has been over, oddly enough, you would think people would be friendlier and nicer, kind of like this several months after the 9/11 incident. Remember, for several months after 9/11, everyone was really nice. You would think that that would have happened with COVID too. People would have kind of taken a step back and gotten some perspective. Not so. People kind of got really, really frustrated and angry. They got let out of their homes, and now they're taking their frustration and anger out on the rest of us, which is not so wonderful. So keep that in mind. Other examples, putting aside the law enforcement, municipal court one. So other examples, these are the non-people on people examples. We see a lot of improper plantings, like I said, patio extensions, parking issues, abandoned cars, unregistered cars, improperly stored cars, people dumping trash. We've had several dumping trash things, storing things on the common property, etc. So that's when you go through the process of notice and an opportunity to be heard. So that's your violation letter. That can come from management or it can come from legal. Your notice and violation letter. Dear Mr. Jones, you are storing a broken down car on the association's common property. It must be removed. You will receive a fine of $50 a day until the car is removed. Notwithstanding that, the fine shall not become due and payable until you've had the opportunity to participate in ADR. Now, the reason why I say opportunity and why that word's so important is it's not that they must first participate in ADR, right? Because many people just blow off the opportunity for ADR. And if you blew off the opportunity for ADR all the time, we would never be able to enforce anything. So the way I like people to think about it, and most of us unfortunately are aware of this, is kind of like the traffic ticket, right? You get a traffic ticket for making an improper right-hand turn on red, and it says, Dear Mr. McGovern, you have a ticket for an illegal right-hand on red, and if you don't contest this, you have a fine of $250 plus 2 points on your license for a moving violation. If you wish to contest it, you must show up in municipal court on the second Tuesday in January and contest it and tell the judge why this is not appropriate to impose on you. So it's the opportunity. As you know, again, those of you who have had traffic tickets, if you don't show up on the second Tuesday in January, the court says, bang, guilty, default judgment. You owe $250 and you get court costs and 2 points or whatever it is on your license. So it's similar to that. A lot of people who are in violation will say, whoa, wait a second. You can't accrue fines against me. You can't do anything against me. You can't try to collect the fine against me. I have not participated in ADR yet. And we say, we gave you the opportunity. You have ample opportunity to participate in ADR. You waive the right to ADR. Okay. Notice and opportunity. We talked about ADR. Many people in the association world now use Community Associations Institute of New Jersey, which has an excellent mediation program. I'm a mediator in the program, and many of my friends are. And it does get cases settled. The issue with it is, number one, it is slammed with ADR issues at the moment. And oftentimes people can't get through the ADR process timely enough. So associations, especially in the age-restricted communities, are using things like the Judiciary Committee or the Covenants Committee to provide ADR. That's fine. I have some clients who use volunteers from the association next door, for example, to do their ADR, and they reciprocate, and then 3 people from the other side do their ADR, which works well too. The most difficult thing with ADR right now is, like I said, finding a mediator, getting a mediator on a timely basis. So that's a real challenge today. That's ADR.
Hey, Fran,
Yeah.
just so everyone's aware, so if you work with a portfolio property manager, oftentimes they can grab a board from another community and have them serve as an ADR committee, and then vice versa, just because you've got a handful of people that are willing to donate their time and volunteer. So that's
great. Yep. So do that, and if you're willing to. A lot of people don't like to serve on ADR committees because they feel like they don't want to be in the middle of a conflict. But I can tell you from my own experience, I really like settling them. Most time, let's say pre-COVID, I probably settled 90% of my cases that were assigned to me. Post-COVID, not as successful. People are a little more cantankerous, but it still is, it feels great to settle the cases. I'm going to keep moving because there are a bunch of questions popping up. Self-help. What is self-help? Self-help is removing the violation. The association removes the violation and charges back the cost of removing the violation. That is a beautiful thing. You need authority to do it in your governing documents, in your bylaws. The board needs the power to do that. So the power to remove the violation and the power to charge back the cost of removing the violation. So I'll give you a classic example is the rules and regulations of the association say no portable basketball hoops allowed to be left in the street overnight. And these people regularly leave it in the middle of the street overnight. And notwithstanding the violation notices and the offers of ADR, they do nothing. The association has the power to exercise self-help and to charge back. So they have their porter come out, wheel away the portable basketball court, store it behind the association's clubhouse, send a letter saying, we took your basketball hoop and you have to pay the $75 or whatever it was for the porter to come out and take it away. That works a lot of times. There are times when it doesn't work. The main time that it doesn't work is if the police are called. So for example, if the resident runs out in the street and says, no, I'm going to chain myself to my portable basketball hoop. You'll never take me alive. And the cops come, right? So the cops come. Cops are peace officers, in my mind, first and foremost, keeping the peace. It's not the Wild West. My experience with police officers is their number one obligation is keep the peace, right? So what usually happens in these types of situations is the association will say, no, we have every right. We have every right to remove this in violation of our documents, etc. And the answer from the police department is no, just go home, go back to your clubhouse. Mr. Jones, you go back in your house. We're going to let a court deal with this. So it's not effective if the police are involved, right? And as you know, the closer you get to their homes, the more difficult it is to exercise self-help, right? Because if you have to go up on their porch or patio to remove the rusty bicycle they've been storing there for 3 years, there's a much greater likelihood that they're going to call the police when you come up. So we don't want people to put themselves in harm's way exercising self-help, but sometimes self-help is a good remedy. We have had lots of success with self-help. Back in the day when people were using a lot of the TV satellite dish antennas, then they would stop the subscription and they would leave the satellite dish antenna screwed to the facade of the condominium association. We would send a letter, they would never remove it. We would go out and remove it and charge them back. Keep in mind though, just because you remove it doesn't mean you own the basketball hoop. You can't just steal people's property. So the other kind of drawback with self-help is if you take someone's item, it still remains theirs. So you have to deal with getting it back to them and storing it in the meantime. A lot of associations do not have facilities for storing things. Fines are great. Fines are great, right? Because they accrue on a per diem basis up to a $5,000 cap for a continuing violation. The problem with fines is lots of people blow them off. And the biggest problem with fines is to collect them, you typically have to hire someone like me and pay an attorney, which is really annoying. And that's the great benefit of self-help. Self-help does two things. It cures the violation and it avoids paying attorney fees, right? So managers just deal with it and you don't have to get the attorney involved, which is great. And like I said, that's often for minor violations. People, for example, who leave their trash cans laying in the street all the time, et cetera, et cetera. Suspension of membership rights. So suspension of membership rights has to be provided for in the association's governing documents. It is a tough thing to balance with the life, health, safety issue, right? So there are people who will say, well, whoa. My governing documents say that you can suspend my membership rights if I am in arrears and not in good standing, or if I do something bad or whatever. But you have to do this, that, and the other thing before you suspend my membership rights. And then, and this happened to me, you get the phone call that says a 70-year-old man just groped a 16-year-old lifeguard. Do you suspend them from the pool immediately and the pool area immediately? Or do you say, dear Mr. Jones, in 10 days, your rights to use the pool deck area will be suspended? My opinion is that life, health, safety, you have to protect your vendors, your members, and your association volunteers. So if it's a life, health, safety issue where someone's been threatened or is at risk, the association has to balance suspension of rights, right, with how the association goes through the process. The governing documents are often very specific on suspension of rights, and they also contain a time limitation. So for example, in that case, with the groping of the lifeguard, the gentleman was suspended from using the pool for a year. And he probably should have been suspended for life. I don't know if it ever came back, but he was suspended for a year, even though, and he agreed to the suspension for a year, even though the association's governing document said you can only suspend membership rights to common elements for 30 days. So in that case, he agreed to the suspension for a year. So you really need, when we talk to suspension of rights in terms of life, health, safety, you really have to balance, because if the associations don't protect, especially their employees, the association can be exposed to suit itself for putting employees at risk. Attorney fees and costs. Most associations' governing documents do not contain provisions for attorney fee shifting with respect to enforcement of violations. So if you have bylaws that do not have that language, you may want to think about doing a bylaw Radburn amendment that provides for that type of fee shifting. The vast majority of governing documents bylaws do provide for fee shifting in terms of collecting association assessments, but they often forget to include attorney fee shifting for enforcing violations of rules and regulations. And what happens, that makes it much easier for people to blow off the association when they are in violation. So you have to be careful about that. So that's attorney fees and costs. You might want to think about your governing documents on that. Discriminatory enforcement. So discrimination is just a word. It always sounds like a dirty word in today's world. But so discriminatory enforcement can relate to several things. It can relate to protected class discrimination, right? Which is extremely wrong and extremely dangerous. Race, color, creed, national origin, et cetera, et cetera. There's a whole litany of them. But it's where you're discriminating against people based on who they are, not based on what they do, right? Very dangerous. And there's remedial legislation at the state level and the federal level, which will severely bang associations for doing that. Attorney fee shifting, punitive awards, et cetera. The other thing, though, and this is what Mike was referring to before, is not protected class. It's pure selective enforcement, right? So selective enforcement, like I said, two people down the street, they have their retaining wall, but we don't like your retaining wall. We're not going to let you have it. Selective enforcement will undercut the association's ability to enforce violations, as Mike said, and judges do not receive that well. You know, the question always becomes in cases of selective enforcement, is it truly selective enforcement, or is it the association has just not gotten around to it? So the classic case is Mr. Jones extends his patio illegally. You send him a violation letter, and he says, wait a second, Fran McGovern, I know there are other people in this community have also extended their patio 2 feet, and you're just picking on me, selective enforcement. The true answer to that is, Mr. Jones, please send us the pictures. Please send us the addresses, and we'll happily go out and investigate it, because we are not allowing that. The other thing is, do you want to get into a modification agreement or a settlement agreement once you do find something, right? So there's a way of remedying violations if the association is okay with a modification, for example, but the person just has not gone through the process with the association. Don't ever forget the fact that the association can always waive fines if the person complies. What you want is compliance. You're not looking to use fines as a cash flow source, right? So if Mr. Jones, for example, extended his patio 2 feet and just did so without going through the process, but the board would have otherwise permitted it, I would encourage associations that I work with to just give Mr. Jones a modification agreement that we would record against his property so that Mr. Jones and anyone who bought the property after him would be bound by that extension agreement and modification agreement. Notice to insurance carriers in case of threat. We talk about this all the time. A lot of times when the violation letter goes out, the immediate response is, you are discriminating against me, or you just don't like me, and I'm going to sue you. As soon as you see those words in an email or anywhere else that says, I'm going to sue the association, please, please, please put the carrier on notice in writing. Okay. Mike, you got anything? You want to jump in?
Well, do we want to get into the questions now? I have a whole bunch here.
Let's see. Let me take a look. I didn't look at the chat yet. There's a bunch of them in there. I had one that somebody emailed me. Let me start with that one. I don't know if it's in the chat room. So
Sure.
There was one I got yesterday. I don't know if I'm interpreting it properly, but it basically says there are restrictions for holiday displays that limit the display of items to within the 5-foot area of the resident's home. Someone installed an oversized menorah actually out on the common property rather than in the 5-foot restricted area. Can association require them to move it off the common grounds and display it in the 5-foot area? My answer to that, again, not legal advice, but my answer to that for educational purposes would, yes, of course, they could have them move it into the 5-foot area as long as the restriction is reasonable. And the planting bed area comes from the state of New Jersey State Constitution, where the court basically said on a free speech basis, Twin Rivers would be reasonable in allowing the signs. That was a sign case, not a menorah case, but a sign case to, as long as it's reasonable within the area specified around the building. Generally speaking, associations can regulate what can and can't go on the common property, right? It's not the unit owner's property. It's not the homeowner's property. The caveat to that, right? The caveat to that, everyone knows religion, right? In both the state and federal constitution, you have the free exercise clause, right? I have whatever religion I happen to have, and I'm allowed to freely exercise my religion. That's free exercise. And then the no establishment clause, which means you can't favor any particular religion. And in the community association context or the condo context, that kind of translates through the Fair Housing Act, right? The Fair Housing Act, which basically says the same thing. So where does it get funky for us? Where you'd have a problem in the example of the oversized menorah being stuck on the common property is if the association allowed other things to be displayed out on the common area as well. So for example, if someone was allowed to put up a Christmas tree out on the common property, as somebody was allowed to be put up a blow up of a Go Giants blow up player out on the common property, but they would not allow the menorah of similar size, you're going to get yourself in trouble because you're discriminating on the basis of religion. Okay, so that's where things get funky. For those of you who know me, you know I've had the baby Jesus case where an association had a Christmas tree in the lobby of the clubhouse, and they had a menorah on the other side of the lobby clubhouse, and someone called and said, and this is basically how he said it, I want the baby Jesus. And I didn't really understand what he was talking about at first, but what he really meant was I would like the manger scene, right? I would like the manger scene. Some people in law call it the creche. And I, at the time, as a young attorney, didn't realize what the case law had to say on that. And really, the case law came down and said, listen, Christmas trees, even though they're called Christmas trees, are not religious symbols. A manger scene and the baby Jesus is, for sure, as is the menorah. So in that case, what happened was the association had to allow the gentleman to have, as he called it, the baby Jesus and the manger scene. Because the association was allowing a menorah. So these things can get very knotty, and you just have to be very careful and very consistent with them, because you don't want to find yourself in a position of being accused of discrimination based on things like religion. Mike, you want to take the next one?
Yeah, sure. It says regarding enforcing the bylaws, is that true in cases where former boards did not enforce, but the current board wants to? So this comes up all the time. I get this question that comes up almost weekly. Prior boards didn't enforce a particular rule or all the rules, and now the new board's in place and they want to enforce them. Rules can be changed by the board, right? They're not set in stone. So new policies can be enacted, they can be enforced by the current sitting board, even if they hadn't been enforced in the past. That being said, if we're going to roll out new enforcements, let's use towing, for example. Let's say you've had on the books for the past 10 years, the right to tow delinquent owners. And now the board says, okay, we're going to enforce this. I don't think the right thing to do is to go out there and tow 20 vehicles on day one. It's probably better off for the association to send out a notice to everybody saying that on, starting next Thursday, whatever, January 1st, we will begin enforcement of our towing resolution. Here's a copy of it. Here's the reminder, so on and so forth. So yes, boards can certainly change them. And if you're going to change a policy that is in place, the board should pass a new resolution. You should record that resolution, placing everyone on notice, placing future purchasers on notice, send out a copy to everybody, and set forth a date. If it's like more of a draconian type measure, like towing a vehicle, we should let people know beforehand when we anticipate starting that.
Okay, thanks, Mike. So Jay, I see Jay Respler up there. So Jay and I were on a Zoom meeting first thing this morning, and now we're closing the day with another Zoom meeting. It's Zoom all around. So hi, Jay. I don't know if I can see you in there, but thanks for attending. Al D'Amato says, hey, realtors don't provide the disclosure about rules and regulations in too many cases. That is 100% true. That is 100% true. I know there are a lot of realtors on this call, which thank you so much. Keep in mind, though, that there are many realtors out there whose only mission in life is to close the deal, which I get, I get that, but the association still has to do the best job they can to try and educate realtors. So there are some associations where they actually do have a little open house, if you will, for realtors. For example, once a year, they have little coffee and donuts or bagels or what have you. And they talk about that because in many associations, it's the same realtors all the time, right? So there's 4 or 5 realtors that basically deal with most of the transactions in the community. So if you can get a hold of their ear and explain to them what they're doing to their clients in not advising of the rules and regulations before they move in, it goes a long way to not getting people jammed up, and it's a benefit to their clients as well. I was threatened with a suit down off of Route 9 down there in Marlboro, and the person said to me, "We had no idea that there was this rule and regulation in place, and we never would have purchased here, and I'm going to sue the association. I'm going to sue you, Fran McGovern." And I said, "Well, I can't tell you what to do. I'm not your lawyer. But you may want to talk to your realtor, and you may want to talk to the realtor the lawyer who handled your closing." Right? The good news is I never heard from them again, so which was good. But people should know the rules and regulations, at least generally moving in. Want to take the next
Fran,
one?
some of the 55 and older communities we work with have the intro meeting. That's, you can't really require it, but they'll say, hey, if you want your pool passes, once you close, come on, and then we're going to sit you down for 15 minutes and hand you the rules and give you a brief overview. And that seems to be pretty effective.
Okay.
The next question says, can ADR come within the same community? So I guess that means, can the ADR committee members reside in the community? The answer is yes, they can. You cannot be a board member, can't be the attorney representing the association, can't be a property manager or anybody else involved in the dispute, but an independent third party who happens to reside in the community, absolutely, you can use that.
So the next question is, let's see. So if a resident violates the rules regarding placement of holiday decorations, for example, limiting to the 5-foot area outside the unit, and management does nothing about it for 2 years, then wants to enforce the regulation, the resident could win in court. Generally, the answer to that is no, Al. The special circumstance that Mike and I were talking about before generally involves things like significant reliance, and also disparate enforcement, right, or selective enforcement. It's pretty rare that courts will say that the association can't enforce and therefore waive the rules and regulations, right? Especially, I don't think a court would find that with respect to something like holiday decorations, because they're easily put up and easily taken down.
And also a difference, Al, between single-family homes where people own from the four corners of their lots, subject to a declaration of restrictive covenants that says what you can and can't do, versus condo associations where the association actually owns all the property outside, and then essentially people own from the sheetrock in.
Right.
All right, the next question, Fran, if you want to take it, whatever. It says,
oh, go ahead, Mike.
all right, if you remove an item and store it, can you advise the resident how long you would hold it before you have a right to discard it? So before we start discarding items that we're taking, I think we look at this more on a case-by-case basis. So if there's actual value to the item, I would be really hesitant to just tell the association to throw it out. I can tell you if you have some abandoned junk that somebody's left in the backyard. So I've had the issue several occasions for whatever reason. There's the old grill that has, like, it's dilapidated, fallen apart, it hasn't been used for years, all rusted away, driving everybody nuts that could see it in the backyard. And the association uses their right to self-help. They take it, bring it to the back of the clubhouse, send a notice to the resident that if you don't come get it in X amount of days, it has a value of nothing, we'll get rid of it. Versus something that actually has real value. We've had associations rely on the same statute that you would use if you evict somebody and they have belongings in the property. You are required to hold that for 33 days and provide notice to them. But I don't think there's a necessarily a right and wrong answer for this. I think it's more on a case-by-case basis.
Okay. So this is a good one by Angela Pizzi. She says, as part of the closing documents, we require the buyers to sign off on having read and received the governing documents and bylaws. That's great. We love that, Angela. Really good. And that's what Mike was referring to before. It's not so much an interview, right? You're not approving, if you will, the person, but you're just saying, hey, listen, we sat down, we showed you what was what, and you acknowledge that we did that.
Fran, I have one that was sent directly to me. It says, can the suspension of rights to use common elements be based on the situation, or do we need to have a list of dollar charges or restrictions on the use of amenities? First of all, I think it depends on what your governing documents say. So usually you have a right to suspend use of the common elements if the person is in violation of the rules and or if they are not in good standing. But I have to tell you, sometimes that language is not in the governing documents. So before we just say you can't do X, Y, Z, let's make sure the right to exclude them is in there. And like Fran had mentioned previously with somebody harassing a lifeguard, it depends on the situation. So where you have an actual, like we had a situation in April of 2020 when every clubhouse in the state was closed. There were some residents that were pretty animated about getting back into the clubhouse, and we had some property managers that were threatened physically, and police had to get involved. The letter to that resident was not, hey, here's 10 days for ADR and so on and so forth. It is, you are not permitted to gain access to the clubhouse or address the property manager directly. So it kind of depends on the situation and what your governing documents say.
Okay. Do you have any experience in dealing with homeowners who either don't know or choose to ignore pet limitations, i.e. number of dogs? So yeah, we have tons of experience in that. It's really, really annoying, especially if you live in a high rise, which we have a lot of high rise clients. And the problem is the Fair Housing Act with respect to application of emotional support animals and or service animals is extremely liberal, extremely liberal. And I could do a whole seminar on this whole topic. But we have lots of experience in that. It's very, very challenging. Very, very challenging because people's medical providers are happily providing letters that say their Shih Tzu is curing whatever, you name it, disorder of the moment. It's amazing what Shih Tzus can do these days.
Fran, a couple of years ago, there was some clarification that came out on this, which actually did limit somebody's ability to just go on the internet and print out a piece of paper that says this is a support animal, because that was permissible for a while. We can now be a little more pointed with our questions, find out how many times they've actually met with the therapist or whomever the person is. So they brought it back a little bit, but it's still extremely, extremely liberally enforced.
Yep.
The next question here says, we have a rule requiring holiday lights be removed 2 weeks after the holiday, but now people are using lighting as year-round decorations. Should we require a property modification, like a condo patio area? So I think this depends on what we're talking about here. If they are, permanently installed spotlights, something like that, perhaps on a condo where they are imposing on the exterior facade of the building that's owned by the association, I think the answer is probably yes. If it's truly just strung lights, I think the board can pass rules pertaining to those lights, that not necessarily holiday decorations, just outdoor lighting. Costco sells the really nice large bulb string lights, and they look beautiful, but you might not want that in the community. So more likely than not, the board would have a right to pass some rules indicating where it would be permissible, if it's permissible. Probably do not need a property modification. That would be something that would be recorded in the county clerk's office and would impact future purchasers of that unit. So it would be a permanent installment, like expanding the patio, for example.
Yeah. So the other thing, keep in mind there is, as New Jersey gets more and more diverse, I think it's already the most diverse state in the country, but as it gets more diverse, keep in mind you have things like Diwali, which is a festival, I believe, of lights, and they put up lights in celebration of Diwali. So, be careful how you pass guidelines like that, and when you insist on guidelines with respect to lights being put up, taken down, etc. I would say, and we haven't had a case on this yet, but I have seen more and more fireworks on Diwali. So that's something that I think we're going to have to keep an eye on, because historically, most associations we worked with have not permitted the use of fireworks within the associations, but I'm seeing that happen more and more with respect to Diwali. So that's going to be, a coming issue, if you will. I'm going to take the next one too, just real quick, Mike. Did you say association can't collect fines if ADR is requested? So that's right. You can't collect fines if ADR is requested until the ADR is over. The opportunity for ADR is over, right? So, you say, hey, there's a violation out there. Fines are going to accrue on a per diem basis until you have the violation gone, but you can't try and collect it or say that you owe it as a debt until after they've had the opportunity to participate in ADR. So.
All right, the next question says, or asks, are there situations where owners can claim to need more than one emotional support dog? And I'm not going to like the answer to this, but the Division of Civil Rights has said yes. So they came out with quite a few question and answers, in like a format of, hey, can somebody have more than one? And the answer is a strong yes, they can. But keep in mind, the note from the doctor or the therapist is not just a dog or two dogs. It is the particular animal that they are requesting. So sometimes we'll have a situation where somebody's dog passes and they get a new dog. And then they show us the same emotional support animal information that they had, from 8 years ago. And the answer to them is, you need this particular animal would have to be the one that is the emotional support animal. But yep, it can be more than one.
Okay. And that's it. So we go to the holidays. Merry Christmas, Happy Hanukkah, Happy New Year. We look forward to a great 2023. We hope all this COVID nonsense and all these other things that we have to get vaccinated for go away. And we look forward to a great New Year. Great seeing everyone. Thank you so much for attending, and see you next year.